Good morning, members of the committee, and thank you for inviting PORAC and PORAC Legal Defense Fund to be here today. PORAC wishes to participate in this process and provide information that's helpful to you, the committee, and members of the public. My name is Ed Fishman. I'm an attorney, and I'm currently the legal administrator for PORAC Legal Defense Fund. LDF is the acronym for it, and it is essentially a nonprofit trust fund that exists to represent and pay for the defense of public safety officers while engaging in the performance of their duties. If they're going to be subject to administrative disciplinary actions, civil lawsuits, or criminal prosecutions, the entity LDF pays for the attorney to defend them. LDF currently exists in California and provides representation for more than 50,000 public safety officers throughout this state and 50,000 more throughout the country, with more than 105,000 members throughout the United States. The investigation and prosecution into officer misconduct, especially criminal prosecutions, is very unique, and it's very different than the investigation and prosecution of the ordinary citizen. It typically arises out of what I refer to a critical incident or officer-involved shooting. An officer is engaged with a subject, force gets escalated, and eventually deadly force is utilized. Upon that occurrence, two investigations spring up. The first is an administrative investigation typically done by the officer's department itself into the propriety of that conduct. The second thing that happens is a criminal investigation, most often done by an outside entity or agency. The criminal investigation, again, is very unique into this process, and it arises out of the fact that there was a homicide. When a police officer uses force and somebody dies, that is a homicide. And the outside entity investigates that decision to use that force and come to a determination as to whether it fits into one of the legal categories to make it justified or not. If it's not, the officer gets prosecuted. And prosecutions happen in California all of the time against law enforcement officers. The two investigations sometimes run in tandem. Sometimes one stops to let the other one proceed first. But again, a very unique aspect of this is a police officer has one significantly less right than a civilian. A civilian who's under investigation has the right to remain silent. It's one of the first things they're told when they're taken into custody. A law enforcement officer does not share that same right. A law enforcement officer who used his weapon, resulting in the death of a citizen, is forced and compelled to make a statement under the threat of insubordination and termination. One very significant difference in the prosecution and investigation into police officer alleged misconduct. There was mention earlier about confidentiality of personnel records. 832.7 of the Penal Code does exist, with very significant and important exceptions that this committee should know. The first and most significant exception is that a prosecutor, such as the gentleman sitting to my right, if he is investigating criminal misconduct of a law enforcement officer, that confidentiality does not apply to him. The prosecutor has unfettered access and discretion into the otherwise confidential records of peace officer records. The second significant exception is what's referred to as the Pitchess motion, and it's found in the evidence code in California under 1054. That allows a judge to get into the records of a peace officer's personnel records upon the showing of good cause. Other distinctions in the investigation and prosecution of law enforcement officers. First, when and if the officer is found guilty, quite often, the sentencing is much more severe and much more harsh. You'll often hear judges speaking about the breach of the public trust. The second aspect is a very unusual enhancement that would involve the use of a firearm during the commission of a crime, if an officer is deemed to have utilized force unnecessarily.
I'm sorry, but for us to have time for the committee members here, perhaps you could just sum up in a minute or two and also address a question about transparency to the public.
One of the most important things I want to summarize is what I've heard referred to today as use of force, and I've heard the correction be utilized about excessive force as compared to the use of force. One of the unique aspects of criminal prosecutions against police officers and investigations into misconduct is the utilization of experts who describe something called the continuum of force. All officers who take somebody into custody utilize some level of force, and the continuum of force, on the one hand, could be as simple as verbal direction, and to the other extreme of deadly force. And the split-second decisions that officers have to make during the process of taking somebody under arrest and dealing with the situation, the continuum changes and experts have to be utilized. As far as transparency, there is a need for transparency, which is why PORAC is here and why PORAC is participating in this process and stands willing and able to give whatever information it can do in order to assist in the process today.
All right, so specifically, Mr. Bibbring and others have brought up that the results of an investigation should be, I won't decide on the details, but that they should be more transparent than they are now. Can you address that?
Right now, the law in California states that the results of the investigation are confidential, and the California Supreme Court, in numerous decisions, has upheld that. There are circumstances, I think as recent as the Long Beach decision, that has authorized and actually directed the release of peace officers' names who were involved in incidents involving uses of force. So I believe that's for the California Supreme Court at this point to be making determinations as to the information.
Yeah, but that's based upon laws that we make here.
Sure.
That could be changed, and I wanted to get your viewpoint on that.
You're looking for my viewpoint or the viewpoint of PORAC, right?
Well, obviously PORAC,
Sure.
and you needn't necessarily respond now because PORAC may not have decided, but that's something which Senator Leno has brought up, and I'm sure will come up in our discussions over the next month or two. And if you're prepared to say something, that's fine. But that is definitely something that's going to be at issue, if not this term, then certainly the next.
And I think that the rules that have been established and the laws that have been established were established for a reason. So certainly, as PORAC is here today, if there are going to be discussions about confidentiality, certainly PORAC would like to be invited to participate in those discussions as well.
Okay, thank you. Questions from committee members? Senator Hancock.
Thank you. I also want to thank Judge Cordell for very specific recommendations, and I'm actually quite interested in knowing if members of the panel have thoughts about any of those. I'm particularly interested in the issue of prohibiting grand juries on the grounds that very much like an internal investigation, you're dealing with people who work together every day and may depend on collegial relationships. And that isn't necessarily the best way to conduct independent investigations. But that there would be required to be preliminary hearings that are open and adversarial, with both sides having a chance to present evidence, or perhaps an independent agency. Now, those are two different alternatives, and I don't know if Mr. Officer Durant, if you have thoughts on that, Mr. Esposito.
Thank you, Chairwoman Hancock. A big part of the reason why PORAC is here today, to you and to Chairman Quirk and to the rest of the committee, is to let each of you know that PORAC wants to be a part of any discussions and will be here to assist in any way possible. With that said, I personally, although PORAC has not completely come out, I do not believe that a separate review board is necessary. I think our current district attorneys, the 58 district attorneys throughout California who are elected by the citizens within those counties, there is a current process in place. With that process, the citizens of those counties elect those individual district attorneys. And while we do have relationships with the district attorneys because of the jobs that we perform in our duties, there is clear transparency what goes on with each of these individual district attorneys. And when and if there is not, the citizens of those communities have the ability to elect a different district attorney. I do not have the statistics for local. Mr. Esposito may, as far as how many officer-involved shootings there may be in various counties. But to have an oversight of 58 different counties in this beautiful state, I think would be very difficult, cumbersome, and I believe our Attorney General has even made some statements to that effect. But ultimately, whether we have separate relations or not, there is a current process in place where each individual county elects their own district attorney. And if they are not pleased with the results, they have the ability to change out that district attorney.
Thank you.
I'm sorry. I also
No.
have a response, if I may.
Okay, but I did have a follow-up question. Don't worry, I'll get there. So it would be your conclusion that the current process is fair and impartial?
Yes, ma'am. I believe that what is currently the practice with each individual district attorney having the ability to review, again, this I think would be most beneficial to Mr. Esposito, but yes, for law enforcement, speaking on behalf of our membership in PORAC, I do fully believe that the current practice in place is working and has done a tremendous job, as Mr. Fishman pointed out. When we have found problems, those problems are prosecuted.
Thank you.
Thank you. I'd like to address 3 points that are part of your overall question. With respect to the grand jury, the Los Angeles County District Attorney's Office, we do not take our officer-involved shootings before the grand jury. Those assessments are made by very experienced expert prosecutors that are trained in these particular cases with our district attorney investigators who are also well trained in these. So to the extent that Judge Cordell talked about the grand jury, we don't use that process. That being said, to eliminate a prosecutor's ability to use that process if necessary, there are instances where it can be beneficial. For example, in an investigative grand jury, where you can compel witnesses to come forward and provide you information that you otherwise wouldn't be able to obtain prior to filing charges. With respect to the transparency issue, we do in Los Angeles provide the legal analysis, a complete legal analysis on the officer-involved shootings to the public. We provide that to the Los Angeles Times every month, and on any Public Records Act request, we turn that over so members of the public have an opportunity to see, and we don't do that in all other cases, only in the officer-involved shooting cases. So there is a degree of transparency in LA for the public to see how we arrive at our particular decision. On the question of an independent prosecutor, I think the LADA's office wholeheartedly disagrees with that concept. I think experienced prosecutors that do this on a daily basis are well equipped and are not cozy to a point with law enforcement that somehow their ability to be unbiased, objective, and reasonable is somehow tainted. Bringing in, I think the Attorney General of California also made a similar statement, and I don't want to quote her, but I think she indicated that the responsibility should rest with the district attorneys, as Mr. Durant has already pointed out. I think that having experienced prosecutors, like we have in Los Angeles, that are well-trained, these are not prosecutors that deal with the rank-and-file police officers that are out on patrol, the ones who are typically the subject of these investigations. The experienced prosecutors in JSID do not deal with those officers on a daily, weekly, monthly basis at all. They're dealing with the internal affairs investigators. They're dealing with our own internal investigators to investigate separately our assessment as prosecutors on whether or not there is or isn't a crime that surrounds an officer-involved shooting.
Okay, thank you.
Madam
So, do you think it would be beneficial? You know, we're looking for best practices here. If LA has a transparency standard of turning these files and cases over to the newspaper and making them part of the public record, making that a standard state policy?
Well, as a point of clarification, we don't turn our files over. We do turn our officer-involved shooting analysis over.
Thank you, that's what I meant.
I think that's a question for the rest of the district attorneys around California, whether or not they feel that the way we do it in LA is the best way for their particular jurisdictions. We certainly have been doing that for a very long time, and we think it's an excellent practice that we engage in Los Angeles.
Yeah,
If I might-
Mr. Fishman?
Thank you. If I may add, there was another, what I would consider high-profile shooting that occurred in the Lodi area involving a mentally ill subject. That was the subject of a large public debate. That particular district attorney also made the findings of the investigation public, which was very, very helpful.
No, and the district attorney in my own county took a highly visible police shooting and had a preliminary hearing.
and-
So I know. One of the things that's of interest, and I'm wondering if we have data on that, because the clock's running, and is, do we know in how many cases of police shootings, and have a breakdown of which went to an independent division, which went to an internal grand jury, and which went, that would be data, I think, that would be very useful to members of this committee in evaluating the problem. One of my concerns was simply LA is, of course, an anomaly. It always is treated as one. It's a very large department. I'm not sure of the extent to which smaller jurisdictions would have the capacity to have a very specialized unit that would not be part of a more collegial approach in working with police officers. But I did just want to know how many cases you investigate in a year in Los Angeles. And
It ranges somewhere between 100 to 200 every year.
And-
It could go up to 300 if we're including officers out committing potential crimes while not in the active duty.
Okay, and do you have a breakdown of the results of those 300-odd hearings that you could give us?
I do not, but suffice it to say, we file criminal charges against police officers every year.
But we don't know the outcome?
The outcome of
The
those,
outcome, yeah,
whether they're found guilty or not.
yeah.
Most of our cases, I can think of one in the last 2 years where I know a jury returned a verdict of not guilty. In most of the cases, the jury either finds some form of a crime, the officer guilty, or the case settles out of court. But I can't recall, and I apologize, but it's a difficult
Yeah.
question to ask of all of our cases, what the jury does as a
No,
result.
no, just aggregate numbers. How many are settled? How many,
I don't have
what
those, I
happens.
don't have that
Okay.
data with me.
thank you.
If I also may add, I looked through the various cases that have, PORAC has defended throughout the last 5 years, and I certainly don't have the numbers, but by my anecdotal review, the vast majority of those cases that got prosecuted were prosecuted by way of the preliminary examination methodology, not by the use of the grand jury. Very, very small percentage of those. And certainly from the perspective of defending a police officer, I would much prefer the true adversarial process of the preliminary examination of preliminary hearing. But I also want to echo the prosecutor's discussion that in rare and occasional circumstances, the use of the investigative grand jury may be important to preserve.
Judge Cordell.
Senator, to all of you, I just want to make clear, what I've heard from my friends here at the table is that what we have in California is a system of hit or miss. It depends on where you live, for how these kinds of cases will even be looked at. And what I'm urging is that there be uniformity here in the state of California, that we have an understanding that when police officers engage in misconduct or engage in conduct that just gets looked at to determine whether or not there is misconduct, that we can expect the same kind of process to happen, whether you're in LA or whether you're in Sacramento or anywhere in between. So I'm encouraging you all to please look at all that. And one other just quick comment. We have one of the most progressive district attorneys in Santa Clara County with Jeff Rosen. And he is very transparent when he looks at cases. And also in Santa Clara County, they do not take officer-involved shootings to criminal grand juries. I think that should be a rule throughout the state. But he basically decided not to bring charges and issued a very clear report about why charges were not going to be brought against an officer who was involved in a shooting. At the same time, a case was brought against that same officer as a result of that shooting, and there was a multi-million-dollar settlement. So even though there was no charges brought, there was still a settlement in that case. So all I'm saying is that it isn't just clearly, this one simple process looking at, well, we allow our DAs to do this. I'm not saying the DAs don't do a good job. I'm saying that there's the appearance of conflict of interest, there is the cozy relationship, and we need to be transparent and with the public. So I'm hoping that you all will consider that when you look at all of these options.
All right.
Thank you.
It is noon, and we all have to get to our caucus meetings. This has been a very productive panel. I want to thank you all for being here. I particularly would like to thank the judge for her very specific recommendations, and we will certainly have PORAC totally involved with any discussions going forward. You can be assured of that. Thank you.
Right, I think we want all the parties involved, and specific recommendations are helpful as well. You should probably say that we will be reconvening the hearing at 1:30, and invite all of you back again, and actually to the extent that some of the panelists can be here too, so they can comment later. This is all very helpful to us right now. Thank you. We're going to resume our joint hearing on law enforcement and community trust in California. As a point of order, there's going to be a slight change in this afternoon's schedule. We're going to begin with the dual perspective panel, which will be followed by law enforcement and the community panels. With that, I would like to invite Jay Piper Ferreira to come up. He is one of the few individuals that I know, although there are probably more, who have walked in both roles profoundly. He grew up in West Oakland and in Berkeley. He previously, or is, 1/3 of an alternative hip-hop band called Flipside, which did a number of the anthems that were used in the 2008 Olympics. He is now a sheriff's deputy in Alameda County, which is part of my district, and he's going to set the stage with a little of his experience in all of those roles. Thank you so much for being here, Piper.
And thank you all. Good afternoon. So my story is a little complex, but I'll keep it short. I grew up in West Oakland, in Berkeley, during the crack epidemic. I lost a lot of friends to violence and juvenile hall and the penitentiary. In Oakland, in 1992, there were 175 murders. And I knew a lot of those guys. Some of them were classmates, some of them were teammates. I remember having conversations with my childhood friends about what we were going to do when the older guys all went to the penitentiary for murder. And some of those guys, some of my friends, when we were 13, chose to sell drugs and stay on the block, and others chose to go into sports, do something productive. I chose to go into sports. A little while later, I found myself at San Francisco State majoring in Black Studies, and I was a counselor at Juvenile Hall, and I started my band. The band was fairly successful. We toured for years, and after coming back from one of our tours in 2009, Oscar Grant was killed at the Fruitvale BART station by BART police officer Johannes Messerly. So growing up in the community and being active in the Black Studies program at San Francisco State and having a band that, speaks to issues that are relevant, societal issues, we found ourselves at the protest. And while at that first protest at the Fruitvale BART station, I remember looking around at what I figure were probably thousands of people, all different races and ages. And I remember thinking, what do we hope to accomplish? What are some concrete goals? What are the objectives? What do we want? And in talking to several people, the recurring theme was, we believed that there were police officers that existed that didn't care about our community or didn't have our values. That's what the protests were saying, and that's what we thought. We believed they existed. So the next question was, well, if we could identify these officers that don't care about our community and somehow get rid of them or fire them, or they would be indicted or released from duty, who would replace them? And that was a question that wasn't answered, because of all of the thousands of people that was at the protest, myself included. I couldn't imagine any of us replacing the officers that we felt didn't care about our community. So if none of us that were there that felt passionate about justice and equality and, having peace officers that upheld our values and cared about us, if none of us would step up to replace those officers, then change would not occur. So with that thought in mind, I spoke to, professors, and I spoke to my family, and I spoke to close friends, and ultimately I decided to pay my way into the police academy. I figured that, if I couldn't step up and at least try to change something, then maybe I should stop talking about it. That was my personal feelings. I'm not a teacher. I'm not a professor. All I can do is what I can do. So I paid my way into the police academy. I didn't know if I would finish it or not. I didn't know if I would be hired, but I was lucky enough to end up giving the commencement speech, and I've been working at the Alameda County Sheriff's Office since, for about the past 4 years. After coming into the world of law enforcement, I learned a lot of things. My eyes were opened to a different perspective, different side of the argument. I learned that the problem is much bigger than I had anticipated, much bigger than we had previously known. We were comfortable with placing all of the blame on law enforcement, but after working in law enforcement, I saw that for example, just yesterday, a call came out. There were 2 black males walking down the street in the community. They had a pit bull, and they were casing the neighborhood. We all showed up and determined that they were doing nothing. That happens every other day. I myself, in an attempt to knock on every door in the community and get to know all of the community members and meet all the apartment building managers, a day later, an email came from an apartment building manager that to my sheriff, to one of the detectives on our agency, that basically said there was an African-American male impersonating a police officer, and he had stolen a uniform. We can focus on law enforcement. We could try to change law enforcement. We could act as if racial profiling only exists within law enforcement, but we'll be fooling ourselves. This is an American problem. It's a human problem. And until we look at it as such, we'll only be dealing with small symptoms. So I'm proud to be working in the sheriff's office in the REACH Crime Prevention Unit. We have a Deputy Sheriff's Activities League that we grew from the ground up that supports 1,300 kids playing soccer. We have youth basketball, we have adult basketball, we have boxing. When we show up and kids are fighting, we don't have to arrest them. We have other options. We can refer them to our programs. And, you know, some critics say, well, you have a soccer program. What is that doing to improve the relationship between law enforcement and the community? Or what is that doing to empower the community? If you have 1,300 kids that are doing something positive, there are only so many hours in a day. It's less time for them to do something negative. If you get their parents to come out and volunteer to be a part of that soccer organization, then you've empowered parents in the community that now have further control over their children's lives and over the reality of the community. They could direct it better. They feel ownership of the community. So I see these things changing. I see these things happening, and I'm just proud to be a part of them. I'll take any questions that anyone may have.